Hello friends, ramifications of Luxmi Traders Punjab Haryana High Court followed in Sai Overseas and others by Delhi High Court. This complex issue of service and communication through portal or otherwise has caused havoc in the GST litigation. Luxmi Traders Punjab Haryana High Court, contrary to the earlier judgments, they say that the uploading on portal is not enough. Communication to the assessee is important. That is, when did the assessee come to know of that order? This is very vague. And they have also given a finding that there was no specific notification under section 146 of CGST Act. When I went through the judgments and the corresponding definitions, there is a definition of common portal in section 2. So once a common portal is notified by GST Council or the GST law, then it's applicable for all the purposes. Why should there be a separate GST portal notification for the purpose of section 169 dealing with the service of notices of order, especially with reference to subclause D? Now, both these judgments have Delhi High Court has simply followed Luxmi Traders, and there was not much of a debate by any government counsel in either of the cases. Now, as far as assessees are concerned, a huge benefit. That is, you simply have to say it was uploaded on portal, not communicated to me, I never got to know about it. Therefore, this limitation will start running when the assessee says when he came to know. Can we have a law like this? So assessee doesn't open the portal for 1 year and revenue cannot prove it was communicated. So that means the limitation of 3 months plus 1 month makes no sense. It's osseous. So it's very difficult to decipher and appreciate the judgment of Luxmi Traders of Punjab Haryana High Court, when to the contrary, they have earlier passed contrary judgments. Allahabad High Court, Bambino International, which is stayed by Supreme Court. Delhi High Court, they simply follow Luxmi Traders. Madras High Court, in their judgment, said that there is no need for any separate notification for section 146 because there is a common GST portal and the law recognizes as one of the service modes in subclause D of section 169 that it should be uploaded on the portal. Now there's a further chaos whether this notice was uploaded in a particular column or not in a particular column. There is no discussion of emails or SMSs. So this differentiation between service of order in terms of section 169 subclause D and communication for the purpose of section 107, no doubt, two words are used by lawmakers and therefore they have to be given interpretation. But the interpretation given by High Court that when did assessee come to know, what are the guidelines on that particular issue? Who will prove? That is, if the department takes no action for 3 years or 4 years for recovery, and once they take action, then I come to know, now I have come to know. Therefore, my right of appeal or filing a writ comes. Will a High Court or Supreme Court hear such matters? Therefore, this issue is very complex. A jurisdictional High Court judgment which is contrary to Luxmi Traders or Sai Overseas will be held applicable. That is, if Calcutta High Court, Madras High Court, Karnataka High Court, whatever High Court, Uttarakhand High Court recently passed a 33-page judgment. So Delhi and Punjab Haryana dealers will get benefit, others will not get benefit. And what about the GST tribunal? Which judgment will be applicable? So both the judgments have caused much more chaos than solved any problem. Now what happens to revenue? Let us consider this. So if all over the Delhi and Punjab, let us say they have passed 5,000 orders like this which may be covered by these two judgments. Now all these 5,000 orders go. They have to be restarted. So determination of demand, recovery tax amounts, appeals shall all be delayed. Now supposing the same judgment is followed by all other high courts, that is, till now whatever judgments have been passed on this ground, will they be reviving? Now the high courts have not said that these judgments will be retrospective or prospective. Now once it's not said it's prospective, so it is the judgment declares the law from the date of the provision. So wherever my appeals has been dismissed at time barred, now I take it to tribunal, I came to know now, or I take it to the first appellate authority, what happens? So these are very big questions. As for revenue, there is a huge problem. There is a lot of remand cases coming up. They will have to redo it. So it causes a lot of burden on the revenue, which they will have to deal with because they are dealing with high court orders. Most of us also have the view, once the two matters are pending in Supreme Court, S.K. Chakrabarti and Bambino International, that is Section 529(2) Limitation Act, or the service or communication in Bambino International, should the high courts have waited? No, there is nothing in any law that high court should wait for a Supreme Court decision unless there is a blanket stay. There is no blanket stay by Supreme Court. Only in Bambino International they have stayed, or a Calcutta specific judgment has been stayed. Other judgments have not been stayed. There is no general stay operating on high courts. So, in fact, as a matter of fact, high court should not keep the matters pending, they should decide. But there is some logic. Once a matter was pending in Supreme Court, they should have deferred the matter. That would have been better. They should have given the orders, okay, the periods from this to this shall be excluded if the Supreme Court decides for or against. Now let us say Supreme Court decides against Luxmi Traders and Delhi High Court Sai Overseas or other such judgments. What happens? So unless Supreme Court says it is retrospective or it says it is prospective, depending on this, the judgments of these high courts shall be subject to that ruling. Now supposing Supreme Court decides against Luxmi Traders and Sai Overseas, so these judgments shall be non-est. That is, the people who got relief before the Supreme Court judgment was passed may not be affected, but the appellants coming after Supreme Court judgments not agreeing with Luxmi Traders or Sai Overseas will suffer irreparable loss because their cases, they will have a problem. Now supposing revenue says Supreme Court declares the law from the date when it comes, and they start reversing the order, they start filing review petitions, okay, no, these orders are bad, therefore our demands had become final, the appellants must pay. So there is one more issue coming up for you. Now we have one more chaos on this issue, that is the special bench of GST, who have still not started hearing the cases. Next date is 16th September. Now all the 31 benches are keeping the matters pending. On what basis? Now if Delhi bench or the Punjab Haryana bench or the other High Court judgments available, why should they wait for an order of special bench? High Court judgment will have persuasive value if there is no jurisdictional High Court judgment. So why really GST benches are waiting? We shall wait until the order of special bench comes. Who is special bench? Special bench has no authority, and whether it's legally constituted or not, whether this is legal or not, that's another question, which is the special bench should allow lawyers to debate whether the GST rules or section 108 has given any power to the GST president to constitute a special bench, where all other benches are keeping the matter pending. So I am, as a lawyer, I am unable to reconcile what are we doing in GST. There's a total chaos happening. One high court says this, other high court says this, other high courts totally disagree with them. So assessees on those states suffer, assessee in Delhi and Punjab will gain. But what have they gained? They have been relegated back to the original proceedings, which they debated. That is, now if the appeal was filed late, they will be relegated to now you can file the appeal now. So what will happen if they want to come back to High Court again, challenging the show cause notice now adjudicated? So again they'll file it in High Court. This is a matter for High Court consideration. The appeal remedy is not efficacious. Then will High Court listen again? Answer is yes. That will be independent proceeding they will have to hear. So friends, these two judgments, in my view, have not solved any problem for the country as a whole. Rather, they are debatable judgments. They have created many problems. And even the GST special bench, who has done nothing for last 3 months on the hearing of limitation issues, which was announced with a lot of fanfare. And in fact, lawyers are not being called to argue the batch cases. They have some 2-3 lawyers whose names come in the cause list. We don't know their background. Therefore, if at all the special bench has to hear the matter, they should allow people to argue. Tomorrow, if I'm not heard, I'm not bound by the special bench order because I'm not been heard. So they are statutory authorities. They do not have constitutional powers to bind people with one order. The tribunal cannot do it. Under what law are they doing it? If you go to High Court, they have the power. They are constitutional courts. Supreme Court is a constitutional court. ITAT and GST are statutory authorities. They are bound by the statutory appellate mechanism where each assessee has a right to be heard. Well, friends, you wanted my views on these two judgments. So my views are that these judgments have created much more chaos. Government councils have really not put in any hard work to get a correct law laid down. They are happy, they'll make their money, whatever fees they get, and the revenue will suffer irreparable job. Even the dealers and professionals will also suffer, because if the proceedings are relegated back to the show cause notice stage or any other stage where it's pending, or the notice was not uploaded and not to communicated, then they have 4 weeks to do this, 4 weeks time or whatever time given by respective High Court to finish this. So let's wait and see what more judicial chaos these judgments bring. These are my frank views. Thank you.